Minutes per side.
Good morning. May it please the Court. My name is Warren Brown, and I represent Wendy's International and Ace USA, the appellants in this matter. I would like to reserve, with the Court's permission, 2 minutes for rebuttal. This case stems from a final order entered by Judge of Compensation Claims Catherine Pecco awarding permanent total disability benefits. There's also a cross appeal as to the correct date of the commencement of the permanent total disability benefits. The facts of this case are rather straightforward. The claimant had a compensable work-related accident in May of 2001 when she slipped and fell. She sustained an injury to her left knee. It's the only injury she sustained. Employer Carrier initially sent out a 120-day letter under Florida Statute 440.20, parentheses 4, in August of 2001. No follow-up was done in terms of a denial or an acceptance on that letter, which resulted in the claimant having a compensable accident. The claimant initially saw Dr. Zagorski, an orthopedic surgeon, then transferred to Dr. Fernandez. Dr. Fernandez performed an arthroscopic surgery in July of 2002, primarily to repair a torn meniscus suffered as a result of the fall. In October of 2002, he placed her at MMI. He gave her various restrictions, and he indicated at that time that there would be no need for any additional surgery as a result of the work-related accident. Shortly thereafter, a petition for benefits was filed for permanent total disability benefits as a result of the October MMI date. In April of 2003, the claimant began retraining with the state of Florida for a security guard position.
Counsel, let me jump through the facts because I think we're very familiar with the facts. And I also want to assume, let's assume for the purpose of this question that the Judge of Compensation claim erred in his ruling on the 120-day rule under our recent, I guess, Checkers Restaurant case. Are we still not obligated to affirm because competent substantial evidence supports the JCC's finding that the claimant suffered a catastrophic injury caused by the industrial accident? And there are findings of causation at 2 points in the order as I see it.
I don't believe that this Court is compelled to affirm because I do not believe that there is competent substantial evidence. When you look at the judge's findings in a whole, she based it on the need for the knee replacement surgery, and if we make your assumption, Your Honor, we don't get to the knee replacement surgery. For example, she discounted the testimony of Gordon Butler regarding job opportunities that were made available for the claimant, and the reason for discounting his testimony, she indicated in her order, was that those job leads were made available when Dr. Fernandez had her on a no-work status due to the recommendation for the knee replacement surgery.
So, so you're saying there's no CSE to support the 5-step Social Security disability analysis?
No, I don't believe that there is, and if you even look at their expert, Mr. Roberts, he admitted in his testimony that the claimant could work in this Social Security job. And if she could do that Social Security job, which she ultimately obtained a license for, then she wouldn't meet the 5-step analysis.
Security job, not social. So she could be a
security
guard.
Security guard, for which she got the license for. And he admitted that she could perform that job.
But he did not realize her condition. Didn't he testify to that effect? That he didn't realize she couldn't walk without assistance, so that if she didn't have the surgery, she couldn't be a security guard.
I don't believe that the record demonstrates that she couldn't walk without assistance. When she was put at MMI again in 2004 by Dr. Fernandez, he said her restrictions were the same as they were in October of 2002. Mr. Roberts had those restrictions available to him when he did his analysis. So nothing in her restrictions that he relied upon changed from the medical perspective after she did that. After he did, or the judge concluded the need for the surgery was related.
But if we don't agree, if we find sufficient evidence that the 5-step analysis has been met, do you concede that there's a basis there for affirming.
Well, I can see that it's the law based from this court that the fact that I can demonstrate that there's competent substantial evidence to find a different holding doesn't mean that you necessarily have to reverse. If the court finds that there was competent substantial evidence to support her award, then I agree that you have to.
And there are two bases, as I see the order for the award. One was her 120-day ruling, saying there's a waiver, and the other was the catastrophic injury fund.
Well, I don't believe that there's two bases, because the only way she gets to the catastrophic injury finding is by using the medical from Dr. Fernandez, that the only way she obtains those medical opinions is to find the waiver of the 120-day rule. Because what happened was that although the claimant initially was put at MMI, sometime later she goes back to Dr. Fernandez. The first time he recommends the knee replacement surgery. There's no competent substantial evidence that the knee replacement surgery is related to this accident.
Well, didn't Dr. Fernandez himself testify that the replacement surgery had been accelerated 10 to 12 years due to the accident?
He did testify to that, but he was asked directly.
Isn't that enough?
I don't believe that's enough, because I believe under the closet-made case, there has to be evidence that the need for the surgery, the major contributing cause, has to be the accident, and that accident has to outweigh the other causes.
Well, and he said that the reason it had to be done now, rather than 10 or 12 years later, was clearly the work-related accident, did he not?
He said that the reason why she needed surgery today as opposed to later was because of the accident, but he didn't say the actual need for the surgery was due to this accident. He said there were three conditions. She had a long-standing degenerative problems in her knee. He classified her as obese, and he said it was a combination of those three factors that required her to have knee replacement surgery. He further indicated that absent the work-related accident, she would have had knee replacement surgery at some point in the future.
But the need for it today was due to the accident. As I read his testimony, that's pretty clear. She probably would require it in 10 years, even if she had not had the accident. But she needs it today because of the accident. Isn't that a fair reading of his testimony?
I believe that's fair, but I think the actual term that he said was it put her over the edge. And when we questioned him about that, what is the percentage that you can apportion to each of these three different causes as to why she needs that knee surgery, the knee replacement surgery, he couldn't answer that. He says, I can't give a percentage. So we don't know whether
Let me help you out here. Do you have a recollection concerning whether or not Dr. Fernandez testified, quote, the major reason for needing a knee replacement now versus in 10 years is the work-related injury, close quote?
Yes, I believe that he testified to that effect, but that was not the only question and answer that he gave.
Isn't that enough?
I don't believe that's enough when you consider his testimony in a whole.
But then
I think that's probably just what the judge did, is that she looked at a certain portion of his testimony, and she didn't look at all of his testimony.
So you're saying that there is no competent substantial evidence to support that quote I just read?
There's competent substantial evidence to support that quote, because I'm not going to argue that he never made that quote. Obviously, he testified to that, but what I'm saying is that when you look at his testimony in a whole, which I think is what we need to do when you look at a witness's testimony, you can't just take his answer to one question. If they had asked him first question out of the box, is she permanently totally disabled, and he said yes, you've got to look at the rest of his testimony, or else there'd be no reason for us.
Is that a credibility call?
Is it a credibility? I don't believe it's a credibility. I think it's an evidentiary issue in terms of what is his actual opinion. We could all sit here and pull out one question versus another, but you have to look at it in a whole, and that's what we tried to stress below, and that's where I don't think the judge did. I'll reserve the remaining time for rebuttal. Thank you.
We'll give you a minute for rebuttal.
Thank you.
Mr. McCabe?
May it please the Court, my name is Bill McCabe. I represent the claimant in this case. We contend that this is nothing more than however it's sliced or argued or whatever, it's nothing more than a competent substantial evidence case, and the issue is whether there's competent substantial evidence to support the JCC's finding that the claimant's permanently totally disabled. There clearly is. The claimant had a compensable injury to her left knee. Dr. Fernandez initially placed her at MMI on October 25th, 2002. He imposed limitations and restrictions upon her, which limited her to sedentary-type activities. There was testimony from a vocational rehabilitation counselor that based on the October 25th, 2002 sedentary restrictions, the claimant would qualify for Social Security disability, that she had a catastrophic injury. And the judge accepted all that testimony. Now, as far as the knee surgery is concerned, first of all, the claimant doesn't want the knee surgery, so knee surgery was never requested. Dr. Fernandez said the limitations and restrictions upon her would be the same if she didn't have the knee surgery as he indicated it would be on October 25th, 2002, and in another disability form he filled out on May 21st, 2003. However, the judge, we submit, correctly did determine that the claimant's current condition and need for knee surgery would in fact be the original accident of May 10th, 2001. First of all, as far as the 120-day thing is concerned, this carrier accepted the lady's condition when it first happened. They never denied the lady's condition at any time until they amended their pretrial stipulation 30 days before the hearing. They filed an amended pretrial stipulation contending that her current condition wasn't related to the accident on June 14th, 2004. The hearing was held on July 14th, 2004.
And there's no suggestion here that anything happened after the initial work-related injury to conceivably change the causation of this.
Correct. There's no other accidents or anything. So the judge, we feel, was right on the 120-day anyway. But secondly, as this court's already noted, Dr. Fernandez's testimony establishes that the major contributing cause of the need for the knee surgery and her current condition is the accident anyway. For example, the very first time that he recommended the knee surgery, which was November 11th, 2003, he states in his report on page 206, the reason of contributing a knee replacement would be the work-related injury. I would state that the work-related injury accelerated the need for a total knee replacement on the left side by an average of 10 to 12 years. And he noted that she was previously asymptomatic before the accident, actually worked 2 jobs before the accident, etc. In his April 14th, 2004 report, on page 202, he states, I therefore believe that the contributing cause for her pain at this point and the need for a total knee replacement is the work-related injury of May 1st, 2001. This should be quite clear to anybody evaluating the case. In his deposition, at one point on page 146, he's asked directly the specific question, is the knee replacement needed now because of the injury? That's at the bottom of page 146. There's an objection from counsel for the employer carrier, asked and answered, but then the witness, yes. And then he testifies in his deposition, as you've indicated, that the injury accelerated the need for the knee replacement by 10 to 12 years. So there's competent evidence in the record based on Dr. Fernandez's testimony anyway that the current condition of this lady and the need for knee replacement is the compensable accident. The only issue we take with the judge's ruling is the judge found that permanent total disability should begin on June 2nd, 2004, and we contend that it actually should have begun on October 25th, 2002.
Doesn't that really relate to the fact that Dr. Fernandez seemed to have some difficulty stating with clarity what the date of MMI actually was?
Yes, he did state, though, initially that she was at MMI on October 25th, 2002, and he imposed those sedentary restrictions upon her. Then nothing happened until the claimant came back in November of 2003, continuing to complain of pain, and at that point he felt that knee replacement surgery would be appropriate. But we would
testify that he had seen some improvement and that it was his opinion that if she didn't have surgery, her MMI date would be June 2, 2004?
Yes, he kind of gave a new MMI date, but we submit that the Emanuel case would apply. That's a situation where the claimant was initially found to be at MMI on a certain date. They felt that he might need knee replacement surgery at some time in the future, but this court indicated that until that occurred, once the person's at MMI from all treatment recommended at that time, they are at MMI and they're entitled to permanent benefits.
Didn't Dr. Fernandez, in fact, provide treatment subsequent to the first MMI date that was not merely palliative?
Well, he did provide treatment for her after, yes. I mean, she...
Could the JCC have concluded that that was more than palliative?
Well,
You see where I'm going with
yes.
that?
It seems... Here's another thing, though, on the MMI date. I mean, that we have to keep in mind. It was... I know the court had this issue, I guess, in the first case, too. But, you know, the parties actually stipulated that the claimant reached MMI on October 25th, 2002.
But have you made that argument here?
Yeah.
Okay.
Yeah, that's in the pretrial stipulation, or it's in, I made the argument, they put it in the pretrial stipulation, and in fact, they even paid the claimant impairment benefits from October 30th, 2002 through December 10th, 2002, based on Dr. Fernandez's MMI, 102502 MMI and permanent impairment date.
And in connection with the final merits hearing, did anyone point out to Judge Pecco that there was no disagreement regarding the MMI date?
The parties stipulated that the MMI...
But did anybody point that out to her at the hearing?
I believe that that was kind of part of the basis of the employer carriers. You know, they were trying to contend that the claimant's knee condition was some new post-MMI knee condition.
Was it raised by motion for rehearing after the merits order came out?
That the claimant...
That, Judge, you found a date here that's inconsistent with the date we've all agreed on.
Not knowing that for sure, I'll have to say probably not.
And you weren't, I understand you weren't the trial lawyer.
Sorry. Thank you, Your Honor.
On the issue of Dr. Fernandez, in the record at page 152, he was asked whether it was consistent with his MMI report from October of 2002 that any further surgery would not be related to the work-related accident, and at that time he indicated that that was correct. Then again on page 163, he's asked, it's those three factors that she needs a knee replacement now, meaning her weight, the degenerative changes, arthritic changes in the knee, and the work accident. Those three factors are why you're recommending a knee replacement now versus 10 years from now. And again, he said yes.
But that doesn't tell us anything about major contributing cause. That just tells us there are three causes.
Right, and that's exactly our...
But didn't he testify at least 5 times that the work-related accident was the major contributing cause for surgery now as opposed to 10 years from now?
I think he testified that that was, in his, like I indicated before in his terms, put her over the edge. I don't think he testified that that was the major contributing cause.
Well, I read you one time when it seemed to me that he did that.
What happens is a lot of times in these cases, the doctors will say one thing on direct examination, another thing on cross-examination. That's why we look at the totality of their testimony. Thank you.
Thank you. Thank you both. That concludes our calendar for this morning. We'll be in recess.